All right. Good morning, everybody. This is Contract Training Series. Today, we're talking about consumer notice in the single showing form. I know we've talked about the single showing form before, but we are going to talk about it again just because it kind of goes hand in hand with the consumer notice. So I always just kind of like to give it a review so that everybody knows. But one of the very first documents that you are going to have a conversation with your clients on is the consumer notice. And this should be provided to every person that you meet when you start to have any type of real conversation about real estate. So this consumer notice, I want to start out by saying, is not a contract. And it actually says that right on the top. This is not a contract. This is more like a statement of rights. So as you meet a new individual, especially an individual who has never purchased or sold a property before, it is important for you to explain to them exactly who real estate brokers and salespeople are, what we do and what we don't do. Okay, so that they know this going in. So this consumer notice that we use here in Pennsylvania kind of solves that so that all parties are on the same page. Now, when do you give the consumer notice? The consumer notice is provided to the client, as they say, when you have the first substantial conversation about real estate. So if you are meeting them at the office and doing a home buyer consultation, you have to give them a consumer notice and have them sign that. If they're talking about getting pre-approved, you need to give them a consumer notice and you need to have them sign it. If you are meeting them at a property to show them a home, you need to give them a consumer notice and have them sign it. Also, if they're making an offer on a property and you should already have a consumer notice signed, always put another consumer notice in the offer packet and have them sign it again, even if they signed one the first time. Okay, it's just good practice. It's a good habit to do. So it should always be part of your offer contract, your offer package. All right. So consumer notice, this is not a contract. In an effort to enable consumers of real estate services to make informed decisions about their business relationships, they may have with a real estate broker or salesperson, also known as licensees, the Real Estate Licensing and Registration Act, RELRA. If you remember that from your studies, RELRA, they talked about RELRA. I think there's like a whole chapter on it. Requires that consumers be provided with this notice at the initial interview. Licensees may enter into the following agency relationships with consumers. All right, so now we're going to go over those. And it's important for you to kind of touch on each one as you're going over this with your client. You do not need to read it word for word with your clients, but I do prefer that you at least touch on some important factors and give them the 10,000-foot overview and then provide them the document so they can review it, read it word for word if they choose to do so. First is a seller agent. As we know, seller's agents represent the seller's interest and the seller's interests alone. That would be a listing agent. So listing a home or a property or a commercial building or even a rental on the market would be a seller's agent. And that seller agent is making good faith to find a buyer or a tenant, except when the property is subject to an existing agreement, meaning that the home is already under contract, all contingencies have been waived. All confidential information relayed by the seller must be kept confidential, except that a licensee must reveal known material facts about the property. All right, so understand that everything that your client tells you is confidential. You can't share that. Even if you are also working as a buyer agent on a transaction, which we're going to get to here in a minute, you cannot break confidentiality with the seller. The same is true for a buyer's agent. A buyer agent is somebody who represents the buyer's side of the transaction only. Okay, again, you are working on behalf of the buyer only. And if they're putting an offer in with a seller, that seller is not also represented by you. Again, you have to keep all information confidential, except material known facts about the property. Now we get into dual agent. Dual agent is when an agent represents both the buyer and the seller in the same transaction. Okay, so this is often kind of gets muddy with some agents. So this is where you can represent both the buyer and the seller in the same transaction. We are a dual agent state here in Pennsylvania. Not all states are dual agent. So in some other states, you can't work as a dual agent. So this is highly important for you to point out, especially if your clients have purchased other property in other states, because this may be new to them. A dual agent may not take any action that is adverse or detrimental to either party, but must disclose material known facts. So again, everything with the buyer and with the seller is confidential. This is a very slippery slope to be in, to be a dual agent. So you cannot give advice or construct an offer when you are a dual agent because you have insider information. So it is important that the parties do this independently and you're not giving advice for or against the other party. Okay, so you have to remain completely neutral as a dual agent. Designated agent. And a lot of agents get really confused when it comes to a designated agent. So we're going to read this together. As a designated agent, the broker of the selected real estate company designates certain licensees within the company to act exclusively as the seller or landlord agent, and other licensees within the company to act exclusively as a buyer tenant agent in the transaction. Because the broker supervises all licensees, the broker automatically serves as a dual agent. Each of the designated licensees are required to act in an applicable capacity explained previously. Additionally, the broker has the duty to take responsible steps to assure the confidentiality information is not disclosed within the company. All right, so when you receive offers, it's not uncommon for, let's say, XYZ company to be the listing agent and Realty One Group to be the buying agent. Okay. And when XYZ gets an offer, you put on there that they are the seller agent and they are the seller agent, that all licensees within the brokerage for XYZ company represent the seller. And then you do the same as the buyer. A lot of agents will come back and say, no, I'm the designated agent. Well, that doesn't really apply. Designated agents means that the brokerage, meaning Realty One Group Ultimate, represents both the seller and the buyer in the same transaction. But inside those transactions, we have two licensees. So let's say Marlene represents the seller and LaDawn represents the buyer. The two of you would individually represent those parties under the umbrella of Realty One Group, who is the dual agent. Okay? That's what designated agency means. I have, throughout my 20 years of a career, have had this discussion with other agents and even other brokers, but it is right here. It is written right here. Okay. So just so that you know what, I want all of you agents to know what designated agent actually means, because it is it's one of the biggest misconceptions when it comes to paperwork. But it is absolutely right here. Designated agency only comes into play when we have an in-house transaction and two separate agents representing two separate parties within that transaction. All right. Transaction licensee. This is becoming more common since NAR has enacted, the changes in 2024. We are seeing more transaction licensees coming through. So a transaction licensee provides real estate services without having any agency agreement with the consumer. So basically an example of a transaction licensee is that there is a seller out there who has maybe sold their home for sale by owner, and then there is a buyer ready to go. And they both want to enter the transaction, but they have no idea what to do. They don't have access to the paperwork. They don't have access to the title providers. They don't understand these steps with contingencies. They want somebody else to hold the escrow, and they need somebody to come in and do the paperwork. Be very careful when it comes to transaction licensees, because you are there to do the paperwork and facilitate the transaction, period. You are not allowed to give any type of real estate advice. All right. You have no duty of loyalty. All right. So you are not providing real estate advice. You are not helping people design an offer. You are not doing any of those things. You are just doing the paperwork. Okay. But again, any material known fact does need to be passed along to the property, to the parties that affects the property. Okay. Any questions thus far? No? All right. So there's a couple bullet points here that go along with all types of agency relationships. Regardless of business relationship selected, all licensees owe consumers the duty to. So remember, it says consumers, not clients. So consumers is a very broad term, which means all people. All people. Clients are when we have an actual agency relationship. So, but consumers means all people, even if they're not your clients. Exercise reasonable professional skill and care, which meets the practice standards required by RELRA. Deal honestly and in good faith. So basically, be a good human. Present as soon as practicable all written offers, counter offers, notices, communications to and from the parties. It says within reasonable, within reasonable time periods as practical. I always tell everybody, like, the standard of practice is 24 hours, but even that can be a little too long. So again, it becomes when practical. So if you get an offer in your email and it's 2 o'clock in the morning and you're sleeping, nobody expects that offer to be out by 2:30 a.m. But it should be out the next morning during business hours where normal people or most people are awake and functioning. But if you get an offer at 3 o'clock p.m. and you don't send it to the seller for 2 days later, you could be in violation of this rule. Comply with the real estate seller disclosure law. Account for all escrows and deposit funds. Disclose as soon as possible any conflicts of interest and financial interest. This is important. So if there is any kind of conflicts of interest, and conflicts of interest can be very broad or it can be very specific depending on the situation. Let's say that you as a real estate agent put your home up for sale, your personal home, and you have ownership in that home. You are required to notify all parties that you are the owner of the home and that you are also a licensed individual representing that home. It needs to be in all advertising. It needs to be in your seller's disclosure. We require an additional addendum for that, just to make it very clear that you are the owner of the home. So that would be considered a conflict of interest. Okay. Provide assistance with document preparation and advise the consumer regarding compliance with laws pertaining to real estate transactions. Advise the consumer to seek expert advice on matters about the transaction beyond the licensee's expertise. This would be especially important if they're asking legal questions that you are not able to answer, because we all do a very good job at staying in our lane. So I tell clients all the time, I'm sorry, I don't know the answer to that. Or even if I do know the answer to that, it may be wrong. So I highly suggest that you contact your attorney. Keep the consumer informed about the transaction and the task to be completed. So you have to keep them informed, and you have to disclose financial interest in service, such as title transfer, preparation services, insurance, so on and so forth. So these are the items that are negotiable between the licensee and the consumer. Okay, so the duration of the licensee's employment, listing agreement, or contract. So it could be a year. It can not be more than a year here in Pennsylvania, but it could be a year. It could be 30 days. It could be 6 months. It could be 8 months. It could be whatever the two people negotiate. The licensee's fees and commissions, and you hear this a lot, that our fees and commissions are always negotiable. Okay, so that works both ways. It means that you can say, hey, this is what I would like to charge, and the consumer can come back and say, well, this is what I want to pay you. And then the negotiation begins. The scope of the licensee's activities or practices. This is also negotiable. So of course, when we're talking about things like commissions and fees, as the commissions and fees are negotiated down, the scope of the licensee's activities or practices can also be negotiated down, or vice versa. As they go up, maybe the scope of your license of your activities or practices increases. And the broker's compensation with sharing fees to other brokers. That means you're sharing your commission with other brokers. All sales agreements must contain the property zoning classification, except where the property is zoned solely or primarily to permit single-family dwellings. And then there is information in here about the Real Estate Recovery Fund. All right. So at the bottom of the page, all you have to do is have your client acknowledge. This is not agreeing to anything. This is just acknowledging. You're going to see that the date section is here, where they fill in the date, they print their name, and then they sign. If you think this is kind of backwards from all of our other forms, it's because it is. Usually you sign, print, and then date, or vice versa. But this one is date, print, sign. So just to call that out. At the bottom here, you are certifying that you gave this to the consumer during your initial interview, and you date, you print, you sign, and then you place your license number. All right. Who has questions on the consumer notice? Nobody? Okay, great. One question I often get is there's lots of different versions about the consumer notice that'll say buyer one, buyer two, seller one, seller two, and so on and so forth. And people ask, which one do I use? Really, the consumer notice is all the same. So whether you're giving it to a buyer, you're giving it to a seller, the consumer notice is all the same. The only reason why you have these up here is because this is how it integrates with SkySlope. So when you go to do, your signature packet, that's how it's going to plug in those signatures. If you have your packet designed in right, where it says, okay, the buyer person is this with this email, the seller is this person with this email. This is for your digital signature. So that's what that is for. The form is not any different. It's just the way that it's formatted for your DigiSign. All right. I have the broker showing contract in here, and I know we went over this already when it came to the BAC, but I just wanted to include it here because a lot of times when we're meeting consumers, especially buyer consumers, we're meeting them at the house the first time. So these two kind of go hand in hand. Since the laws have changed in 2024, you must provide the consumer a consumer notice as well as some type of showing agreement before you can show them their first home or have any type of substantial real estate conversation with them. So I wanted to include it here just quickly. What I highly suggest is printing off a bunch of consumer notices and a bunch of broker showing contracts and keeping those on a clipboard for easy use, and just kind of like rotating those to the top. So as you're showing a buyer a home, they should be signing the consumer notice, going over the broker showing contract with them for that first house. So those should almost be like stapled together. And as they sign that and you sign it, you kind of put it to the back of your clipboard, and then you have the fresh one on top. Okay. But definitely something that I suggest. It gets you in a really good habit. And that way, if you're ever audited on if you had those signed, they're right there on your clipboard, and you can go back and say, yes, here it is. I not only have the PDF version, but I also have it in my clipboard as well. So we're not going to go too much into the buyer showing contract, but I just wanted to, let you know that they do often go hand in hand, especially with first-time buyer appointments. So it's just a really good habit to get into. But again, to fill this out, you do the subject property right here. This is the broker fee, which we at this office do not charge. So we do not charge them a showing fee. So that would be $0. Down here at the bottom, you're going to put in whatever you charge typically for a transaction. So again, this is all hypothetical. I'm not telling you what to charge because that would be unlawful of me. But let's say that you charge 3% of the purchase price, or $32.50 minimum and $685. That's what you would put in there. Again, completely hypothetical. You don't have to do what I'm saying. I'm not telling you what to charge. There will be a non-refundable fee we do not charge non-refundable fees. So you would put $0 in here, and then you would have the buyer sign and date, and then you would sign as well, accepting this agreement for the single showing. All right, perfect. Let me know your questions. Any questions? Any questions? No? All right, great. Hopefully I did a great job at explaining this to you and it wasn't too boring. I know going over contracts can be, it's not the most exhilarating thing to learn about, but I think it does help to know exactly what that says in real terms so that you can tell your clients what they say. Sometimes the forms, especially as a new agent, can be a little overwhelming because there are so many of them of what they are, what they say, how to use them. But when we break them down in contract by contract trainings, I think a lot of times it's easier to understand. It's easier to kind of grasp that information and then know how to use them going forward. So I want to thank you guys for joining me today. I hope to see you later on today if you stop by the Newcastle office. But if not, have an amazing rest of your day. And I'm just a phone call away if you need me.